Well, good afternoon and good morning, everyone, and welcome to Thrive, a monthly webinar series brought to you by ArcPoint Labs, your single source employer solutions provider, helping business leaders create compliant, safe, and healthy workplaces that thrive. Today's topic, reducing legal risk in the workplace, real legal lessons involving corrective action, termination, and drug and alcohol related issues. My name is Ryan West, your host and Thrive specialist, and honored to share the virtual floor once again with attorney Thom Cope. But before I pass the mic to Thom, a few brief important announcements. First, ArcPoint's Thrive webinar series, held the third Thursday of every month. They're free to attend, they're accredited for credentialed HR professionals, and offer timely and practical info and guidance on a variety of topics, all anchored in ArcPoint's suite of employer solutions. Today's topic is grounded in ArcPoint's drug and alcohol testing solutions, both DOT and non-DOT, policy development, supervisory training, and even well-being solutions, ArcPoint's comprehensive employee assistance program. Next month, we're excited to feature guest speaker, attorney Jenna Shives, who will conclude our Q2 Reducing Legal Risk in the Workplace series by sharing her expert insights on how to build and implement an employee handbook that actually works. An excellent segue to today's topic and culmination of this legal series. You don't want to miss it. Registration for next month's webinar is now live, and you can register immediately by clicking on the link in the chat. Second, once today's webinar concludes, there will be a survey asking for your feedback. The process is super quick, it's easy, and it gives your voice an anonymous platform to influence the type of content you consume. For example, marijuana keeps showing up in the post-webinar feedback, more specifically, medical marijuana. We hear you, and so on Thursday, July 18th, we're bringing in a nationally recognized expert, addiction medicine physician and experienced medical review officer to talk about medical cannabis, CBD, and safety-sensitive work, why this is not like other medications. Really excited for that talk. More details to follow. Keep an eye on your inbox for more info. And lastly, I want to quickly address the frequently asked questions that we get at the beginning and end of our Thrive webinars. To save time, we're posting the FAQs in the chat. So look in the chat for the FAQs. However, I do want to emphasize an important point about certificates of attendance. If you're here to acquire some helpful takeaways, perhaps get a question or two answered by our expert, excellent. Welcome. We're always glad to have you. But if you'd like a certificate of attendance emailed to you, make sure that you're not only registered and logged into Thrive webinars under your name, but that you also attend the entirety of each webinar from start to finish. Okay? Any questions, let me know. Please go to the chat to review the other FAQs. Also say hello. Let us know where you're logging in from. If you have questions for our presenter, please use the Q&A function in the chat for everything else. Any commentary, stories you'd like to share, if you want to interact with one another, which we encourage, please use the chat. If you have a question you'd like our expert speaker to answer, please use the Q&A function so we can actually address it. Welcome, everyone. Good to see people in the chat. It is now my pleasure to introduce today's presenter, an encore specialist. He's back once again, a man who could be playing a round of golf or two, but chose Thrive instead. The highly experienced attorney, Mr. Thom Cope. Thom has practiced labor and employment law for more than 53 years. He has also served as a judge in the area of public employment law, has been recognized in Best Lawyers in America, Arizona's Finest Lawyers, and Southwest Super Lawyers. And in 2021, Thom received the Rogers Hayden Award for outstanding achievement from the Labor and Employment section of the Arizona State Bar. Thom is a partner with Mesh, Clark, and Rothschild and draws on decades of employment law practice to help employers avoid preventable workplace mistakes before they escalate into legal disputes. Thom, welcome back. Great to see you again. The floor is yours.
Thank you, Ryan. I want to thank Ryan and Kisty from ArcPoint Corporate and my rockstar ArcPoint person here in Tucson, Colleen Edwards, for the opportunity to speak to you today. We're going to talk about corrective action, termination, drug and alcohol related issues. But before that, I think Ryan has a seminar or a couple of polls that we would like you to fill out. And then once we have the results, we will talk about them and how what you see in your workplace as problems or solutions. And while that poll is going on, I will continue to discuss what we're going to talk about today. So, Ryan, if you want to shoot that poll out to everybody, that'd be great.
Yes, sir. The poll is now live. Everyone is encouraged to participate.
Okie doke. So, moving on. So, I want you to think about a lot of things today, but what's really important to you, and to that, I like you to think about this acronym WIN. What's important now? And what's important now is that you don't manage people. You lead people and you manage processes. Just think about that in your everyday world. And I think that will help you to understand where we're going today. All right. We're going to talk about corrective action. We're going to talk about termination. And we're going to talk about dealing with drug and alcohol related issues. Now, the interesting thing about this is that I did not have time to look at 50 state laws on drug and alcohol testing. And there's a reason I don't want to need, or I don't even need to do that. Because why? Because ArcPoint does that for you. So whatever state you're in, you have a drug and alcohol law of some kind. ArcPoint will know what that is and how to deal with it. So for today, for illustrative purposes only, I've used Arizona statutes, which I know I practice law in California, Nebraska, and New York State, New York City to be exact. And these laws that I'm showing you, will show you later in the program today, are pretty much line up with what's going on in the other three states I practiced. So, having said that, let's talk about corrective action. So, corrective action is what I don't like the word discipline. When I do handbooks, and Jenna will probably talk about this in way greater detail. When I do handbooks, and I do a load of handbooks, revisions and from scratch, every year I probably do 10 or 15 handbooks, give or take. But the one thing I always do, I get rid of the word discipline and I say corrective action. And why do I say corrective action? I say corrective action because we don't want to punish people. We don't want to discipline them like the military or the school or a parent. We are there for one reason only, and that is to correct their workplace behavior. And that's what's important for the company to understand. So if you look at this little cube that I put together, hopefully you can read it. It's a little, I tried to change the coloring a little bit, but it didn't work. So you're kind of stuck with what I have here. But remember one thing, and think about this. I've often said a lot in the workplace that, people want to do the golden rule, right? Treat people like you want to be treated. I change that golden rule a little bit and I give it a tweak and I say, treat people like they want to be treated, right? That's more important than treating people how you want to be treated. And so remember, if you look at this slide and you look at the first box, remember that it's a person with emotion. That's important. The other thing is we're trying not to belittle or chastise people. What we're trying to do, look, if you have somebody that comes in late every day, what is the goal of corrective action in that scenario? The goal in that scenario is to get the person to come to work on time. Right? So we have to find a way, and we have to find a method to convince that person to come to work on time. And if we have to say something like, well, next couple of times you're late, you won't have to worry about coming in late because you won't have a job here. I mean, sometimes you just have to put the hammer down and really say what you mean. And that is, if you can't correct your behavior and your workplace performance, whatever that might be, you're just not going to have a job here. And remember also that people have self-respect, and shouting at them is not helpful. The other thing is I have, how many cases have I ever had over the last 50, well, before 54 years coming up in June, where people are disciplining their employees or correcting their behavior. Actually, when you're doing it in front of peers, it's really discipline, right? Then you're really making people feel small and belittled. And three things happen when you discipline somebody or give corrective action to somebody in front of their peers. One, you look like a jerk. Two, the person that you're trying to correct is not listening. And three, the message is out there that you don't respect people because you're not taking them into a private office and tell them what they need to be told. The other thing is that I always allow, or I want my clients to allow their employees to tell their side of the story. Why am I late? Because my bus, I mean, I'm in New York City. The bus is running late. It's snowing. It's raining. I can't get a subway train because it's packed. Trust me, I've lived through all of that in New York City. And so there are a lot of reasons why people come in late. And there are also a lot of reasons how they can fix that. If you think you're going to be late on the subway, take an earlier train, obviously. So things of that nature. And then the one word that if you don't learn anything else today, and you don't do anything else with this seminar today, and you throw away the slides and you don't log in anymore, the one word I want you to remember is documentation. If it isn't written down, it didn't happen. Now, I don't know how many of you are repeat from last month, but I wanted to relate a story about documentation. And that is I represented a man who was working for a company, an insurance company to be exact, and he'd been there 17 years. And over the 17 years, he had every performance evaluation was walk on water. The guy never missed a beat. It was always perfect. And then one day he gets a new supervisor. The new supervisor says, well, you're not really doing your job very well, and I'm going to try to demote you. But in the meantime, what I'm going to do is I'm going to give you a performance evaluation. He gives the performance evaluation to the employee, and it's again, walk on water. He fires the employee 2 weeks later for poor performance. So now the documentation in the file for a person that just got fired after 17 years was walk on water. And 2 weeks before the termination was a great evaluation. So the documentation of this company was that the guy was a great employee. So we have a jury trial. And in this jury trial, I asked the gentleman this question. You gave the man a performance evaluation that said he was great. And now you're telling this jury that he was horrible and that that the evaluation really didn't match up with his performance. So you see that name on the top of that performance evaluation, XYZ Insurance Company. So that's a company document, isn't that right? Yes, it is. And so what I'm asking you, sir, is did you lie on your evaluation? Did you lie in a company document? Or are you lying to the jury now about that he was a bad employee? And I will tell you that we got a very nice jury verdict for that man. And I will tell you that the documentation or lack thereof sunk that company big time. So I want you to think about documentation and accurate documentation. So when we're talking about corrective action, let's think about what we really need. What is the one thing you don't want to hear from your employee when you're doing corrective action? You never told me I was supposed to do this. You never told me this was one of my job duties. Or I didn't know I had to come to work on time. As long as I get my work done, who cares? Communicate the rules. Make sure you have written work rules. And Jenna will talk about that in the handbook issues. I like the idea of progressive discipline, but I also don't want to be married to progressive discipline. Every handbook that I ever wrote and continue to write will say, we will try progressive discipline, but at any time in the process, we can move to the final step of termination, regardless of what steps that came before that. I also like the fact that we employers should log their discipline. In other words, keep a track of how many times you told the employee to come to work on time and be consistent. And I had a case once where the employee uh, was actually not doing her job, but the problem was the person didn't write it up at the time that it happened. So, like a month and a half, 2 months later, she did the same thing. And then they wrote her up for the first one, and then wrote her up again for the second one, which makes zero sense. If the idea of corrective action is to correct behavior and correct performance issues, please do the corrective action at the time that it occurs, at the time that the poor performance or the breaking of the rules, whatever it is, do your corrective action at the time it occurs and do not delay.
Tom, this may be a good moment. I know we're going to defer questions to the end, but it's right on time. Catherine says, so if you have a previous walk-on water employee that is currently a dumpster fire, document the change with them and then work on termination if necessary.
I think that's well said. I think what we would like to do if a person is now there may be think about this for a second to answer your question, Catherine. Think about why all of a sudden is this person from walk on water to dumpster fire? Is there something going on in that person's life that's making this radical change? And if it's not, and the person just is not engaged anymore, we write it up, we do the corrective action, and we continue to monitor the situation. And if it doesn't get better, there's the door. Please don't let it hurt you on the way out. So absolutely. If you have people that are good performers historically, but then are tanking in whatever job, maybe you put them in a different role. Maybe they're not in the right role. Maybe they got promoted. A lot of people are not, should not be promoted just because they do one good thing and or do one thing in their job well. So there are a lot of reasons why people tank after being good performers. But to your point, we want to do the corrective action, and then we definitely want to keep an eye on it, keep a monitor it. If it doesn't work out, see you later. And we're going to talk about termination in a couple minutes. So
Tom,
yeah,
one
I
last
think that's
follow-up
good.
from Catherine, and it strikes me as the response could be very subjective, but in your 53 plus years working as an attorney, how much empathy should be given in this particular scenario? What would you say to that?
Well, empathy is a good thing overall in the world, but in the workplace, what we care about is performance. And if unless there's some empathetic reason why a person maybe lost a spouse, lost a child, what I mean, there could be a host of reasons. Their empathy might take place, and there might be a place for that. But if it's just a flat out poor performance, then I'm not as empathetic as I would be if there was a personal reason for something like that.
Yeah. I've always said, people assume that being assertive and being a disciplinarian, right, being a rule follower can't coexist with an empathetic individual, a compassionate individual. And I think that they can. I think you can be empathic and also be strict and enforce the rules,
I,
right?
I agree with that. And there is room for empathy. There is room for some subjectivity. But at the end of the day, you're running a company or you're managing a process and you're trying to lead these people. And believe me, one of the reasons that people fail as a leader is they don't treat people consistently. And so if you see somebody that's not doing their job, so are your coworkers or so are their coworkers. And if you don't do something about it, you're not going to be respected as a leader.
Wonderful. Couldn't agree more, Tom. Hey, last thing, and then I'll go back on mute. I have shared the polling results. 122 people have voiced their opinion. Can you see that on your screen?
I see that correction. Yep, I see that.
Yeah. So the majority of individuals have selected as their greatest legal concern is termination or separation, and then as what you just mentioned a moment ago, inconsistent supervisory actions not being consistent. And then the majority of individuals, 58, stated they are somewhat confident in their documentation practices that would support a difficult employee decision.
Okay. So I'm looking here at this seminar. Termination or separation is the decision the greatest legal concern. And I would actually agree with that. Um, but right up there next to it would be the inconsistent supervisory actions. I think that's so 32% went with termination, 25% went with inconsistent, and not sure it was 24% for not quite sure, depends on the situation. But I will tell you that for all the times that I get called for representation, termination is the number one reason why people file lawsuits or discrimination complaints. So the next one question is, how confident are you that your organization's documentation practices support a difficult employment decision? Not very many people are very confident, somewhat confident. So 48% said somewhat confident. Well, that's a good, that's actually not too bad. I was expecting there to be people saying, I'm not really all that confident. You know what you need to worry about on that? Not that your practices or that your policies are wrong. The fact that what you have to worry about is your supervisors following the policy and doing the corrective action at the proper time. So you're somewhat confident that your organization's practices are right, but how confident are you that your supervisors are doing it properly? That may be another good follow-up question.
Tom, I just to clarify, because I think what you just said is critically important for our audience members to hear and understand. Of course, having an up-to-date, modern, compliant policy is important, of course. But it sounds like what you just said is actually more important that the front line, the frontline supervisors, managers are following the policy that is in place. Is that
Correct.
correct?
That's absolutely right. So, I mean, I represent companies with 5 employees and 5,000 employees. And I sue companies with 5 employees and 30,000 employees. And they all have policies. Everybody's got a policy. But why is it that I'm successful when I sue on behalf of an employee? And I only do about 15% employee work and 85% defense work. But why am I successful in my plaintiff's practice is because people don't follow their own policies, right? You got a policy that needs to be followed, and your supervisor or manager is not doing it. And he or she or they are being inconsistent. So that's a huge problem for employers. And the bigger the company, the less consistency you have amongst your supervisors. So let's assume for a moment you have a no tolerance tardiness policy. Well, that's the company policy, but you have supervisors that are going to allow a person to come to work 15 minutes late, 10 minutes late. You have other supervisors that are going to toe the line and say, if you're not here by 8 o'clock, you're late, and we're going to write you up. That's another big to do in my world when you have supervisors that are not consistent throughout the organization. So I got to move on a little bit because we have a few more things to cover. So when we come to corrective action, a verbal warning without documentation, when you do a verbal, if you do a verbal corrective action, please put it down and write a little note to the file about it. Because otherwise, if you don't do that, you know the employee is going to say in a deposition or in a court case, "I never told me. I don't know anything about it. They never told me anything about this. This is all news to me." So if you write it down and even a verbal warning, do it right. And don't file corrective action unless they're signed. But I like to have the associate or employee sign the documentation. And it doesn't have to be that they agree with it, just that they sign it. And if they don't want to sign it, Let's get a witness in there that you actually gave the documentation to the employee. Try to be consistent in your applications for corrective action and always have a thorough investigation. So, question for the audience. What is the single most mistake employers make in terminations? What is the single most mistake employers make in terminations? You don't have to put it in the chat, but I'm going to give you the answer because time is of the essence. Not firing the person soon enough. People, you need to fire people when they need to be fired. I will stand behind you. I will have your back. I will have the company's back if you fire a person when they should be fired. How many cases have I had, and I will say hundreds, where the employer comes to me and says, I should have fired Sally last week. This week, what she did, she filed a workers' comp claim, or she filed an absenteeism FMLA, or she filed a discrimination complaint. And now here I am. If I fire the person now, it's going to look like retaliation. So then we have to go through this whole drill about, well, you thought about firing her last week or 2 weeks ago or a month ago, and now she's filed a workers' comp claim. Has her performance changed any? No. Well, we can still fire her. You realize that you may terminate people even though they're on workers' comp. You may terminate them even after they file a discrimination complaint. You may terminate them while they're on FMLA for performance-related reasons, right? Performance-related reasons. If you'd already made the decision to get rid of the person, the fact that they filed a discrimination complaint, sure, you're going to get a retaliation complaint back. But with your documentation that we've talked about is solid, you will have no problem. Well, you may not no problem, but you're going to have to make some effort. But you will be able to prevail in those cases. I have prevailed 99% of the time when the company has got good and well-documented situations. All right. So another thing I will tell you, and this is one of the things I put in my book, people fire themselves. All you are is the messenger. Do not hesitate to be the messenger. When I say people fire themselves is, look, you've warned them, you've given them an opportunity, you've warned them, you've given them an opportunity, you've done the progressive discipline, and what happened? There's still, as Kevin said, a dumpster fire. I like that term, by the way. Um, I haven't heard that I haven't heard that expressed in regard to employees, but works for me. People fire themselves. If they're not going to perform, what other choice do you have? You've given them every opportunity to succeed. So again, you're just a messenger. You are not, don't feel guilty about being a messenger because that actually is your role. If that is your role, that is something you have to do. That's what they're paying you the big bucks for. However, let's try to think about this. Why is it? Why is it that everybody wants to terminate somebody on a Friday? What is it about Fridays that makes everybody want to terminate them on that day? You have made a decision the week before, let's say on a Thursday, you and your management team get together. You say, Tom's got to go. He's just got to go. I've tried and I've tried, given him 35 million chances. And what happens? He's still not doing it. I'll wait till Friday next week. Well, why don't you terminate on Monday? Why don't you terminate on Tuesday? There's no magic about Friday. So I encourage my clients to terminate people when they need to be terminated and on the day that they make the decision or very close thereto to get their ducks in a row. I like to have the termination be done in the first 10 minutes of the meeting. None of this stuff, how's the wife and kids? How's the husband and children? How's your day going? Platitudes like that are not helpful. I will tell you, so reducing the risk. When you have made the decision to terminate somebody, do not argue. There is no merit or benefit to arguing. And platitudes like, I know how you feel. This is a real blessing in disguise. That's a problem. maybe you've been terminated. Maybe you do know how they feel. But at that point in time, that is not the thing to say. Constructive discharge. In Arizona, we actually have a statute on constructive discharge, and many other states do too. But the concept of constructive discharge is that you, the employer, or your supervisors, or your leaders, or your managers, are making life so miserable for an employee that a reasonable person would quit their job under similar circumstances. The point of that is it's not illegal to have a jerk for a boss, right? I mean, you can be the biggest jerk on the planet and it's not illegal. It's when you're a jerk because they're in a protected status. Race, color, creed, national origin, religion, ADA, all of that, age, all of that is protected status. If you're making a person's life so miserable on those bases, that's called constructive discharge. I put an example, sexual harassment. I think I told you last week about, or last month, I told you about my client who was of color and he had a hangman's noose hanging off his mirror all the time. That forced him to quit. I had my clients that are sexually harassed, that forces them to quit. So think about constructive discharge as another way that employees leave the company and not in a good way. So I'm going to quickly switch gears to your employee's grow room. So this is actually a grow room of marijuana, in case you didn't know what marijuana looked like in the rough. And I actually took this picture in Colorado where it was legal, or where that particular grow room is legal. It's not legal in every state, trust me. And at the time I took this picture, this would have been an illegal grow room in Arizona. But I just thought you'd like to see what marijuana in a grow room looks like. So, like I told you at the very beginning, I cannot possibly tell you all 50 states' drug laws. So let's just talk about it generically and Arc Point will tell you, your local Arc Point folks will tell you what's legal or not legal in your state. Do you have a medical marijuana statute in your state? Is recreational marijuana legal in your state? Do you have a safety sensitive job statute? Do you have employee drug testing statute? And the big thing is, do you have a written drug and alcohol policy? And if not, please stay tuned for next month because they're going to tell you, Jenna's going to tell you how to do one. But you would definitely need a drug and alcohol policy. And so, interestingly enough, how do you know if someone is impaired under marijuana? A positive drug test is not the answer. The answer is you really don't. Why? Because in alcohol, it's 0.08 in Arizona, maybe 0.08 somewhere else. 0.08 is a standard for being supposedly impaired in Arizona in alcohol. However, in marijuana, there's no standard or definition of impairment. So we have a problem. But Arizona legislature to the rescue. We may, in Arizona, determine that somebody is impaired by looking at some of the following appearance, their clothing has odor, they're negligent or careless in the operating machinery, they're involved in an accident that results in injury, the employee has symptoms of reasonable suspicion, they can't put together a declarative sentence, they can't talk properly, they can't walk properly, whatever. There are a lot of subjective ways to determine if a person is under the influence or impaired. Now in Arizona, we also have a safety sensitive position. And many states have safety sensitive position statutes so that if a person is operating machinery, driving a car on your time, or any one of a number of hazardous things, forklift drivers, whatever, that even if you have a recreational marijuana statute like Arizona does, which by the way passed with 51.1% of the vote to make recreational marijuana legal in Arizona. you still may terminate people for being impaired or even test positive if in a safety sensitive position. So check your local laws because that's real important. Now, here are your legal problems. Retention, negligent retention lawsuits by third parties. So let's assume for a moment that you have um, tested this person for drugs and alcohol. They come back positive for marijuana, THC. Okay. Now you're like, well, I can't tell if the person's impaired or not because they didn't really look impaired. And I'm 5'1", weigh 125 pounds, and if I have 1 ounce of marijuana cigarette, I'm going to be impaired in about 2 seconds. If you have an employee that's 6'4" and weighs 250, they're not going to be as impaired because they're able to metabolize that THC slower or faster, or however your drug people will tell you if it's faster or slower. But whatever it is, I'm going to be impaired a lot quicker than somebody who's a bigger mass person. But what happens now if that person's driving your vehicle and getting in a wreck with a third party, and they find out that they tested positive and you still let them drive? You're going to get a negligent hire lawsuit. And customers, same thing. And employees may sue you to challenge your subjective view of impairment, which is why I always counsel my employers, clients, have two people observe the employee, have two people observe the employee to make sure that they're both aligned with this person's definitely impaired in the workplace. I'm sending them over to our point for a drug test, or I'm going to get them out of the vehicle and do whatever I need to do to get them at home. So always have two people because you don't want to have a he said, she said, or he said, she said situation on who's impaired and who's not impaired, especially when it's subjective. So this would be your brownie with marijuana in it. Always good to have. If you're into marijuana like that, it's nice to. By the way, did you know that the number one way people ingest marijuana is through edibles? Just so you know. All right. Can you test? Pre-employment, yes. Random, yes. Reasonable suspicion, yes. Check your state laws or ask your ARC Point rep. But let's think about it a little bit. We can do it through breath, saliva, urine, hair, and the DOT, if you're a DOT employer, may require confirmation testing. So I just wanted to give you, you'll get all the slides and everything, and I'm not going to read all these slides because we're going to want to get into Q&A here in a minute. But in Arizona and every state in the union that I did some quick checks on alcohol and controlled substances. Almost everybody's got one of these statutes. Then you got the good faith means reasonable reliance on fact and which is held out to be factual without the intent to deceive. So what this statute is all about, it's about observed conduct, behavior, and appearance, and whether or not you can uh, find out whether or not a person's impaired subjectively. And you got written, electronic, or verbal statement, lawful video surveillance, records of government agencies, enforcements, results of the test for use of drug and alcohol, other information reasonably reliable and accurate. All of these different areas and different points are ways that you can show that a person is impaired. And for a definition of impairment, I'm not going to read all this, but you can look at this slide, and I think you'll find that if you can pick two or three of these points, and here's the second part of that, two or three of these points, you will find that person is impaired. So, having said that, what do you need? You need an employment policy in your handbook. You need drug testing policy under your law. You definitely need consistency in application and treat everybody the same. I don't care if it's the owner's daughter or the owner's son, or the owner's wife, the owner's husband. I don't care. They need to be treated the same as every single other employee. Otherwise, your drug and alcohol policy is not worth the powder to blow it up. No exceptions. I'm a huge fan of no exceptions. So to recap what we've done, we've talked about corrective action. We've talked about some termination strategy. We briefly touched on alcohol and drug issues. And I think we're going to turn it over to, hang on just a second. Yep, we're going to turn it over to Ryan for the question and answer session right now. I have one last slide to share with you at the end. And let's try some question and answers, Ryan.
Yeah, let's do it, Tom. We've got some great questions coming through here. First
Perfect.
is from LaDonna. LaDonna, thank you for submitting it. She asked, what is the line between operating as an at-will company and termination of an employee without actual reasoning that may lead to a lawsuit?
That's a terrific question. So if you're in an at-will state, at will means that you may terminate someone anytime, at any reason, at any time for no reason, as long as it's not an illegal reason. The person can then conversely quit with no notice, no reason, just walk out the door, put the keys on the table and say goodbye. You may terminate anybody in an at-will state for anything. Like you don't like my blue shirt, you can fire me because I'm wearing a blue shirt. It could be a dumbest reason on the planet, but it's not illegal. So if you're in an at-will state like Arizona and apparently Ladonna state, you may terminate somebody without cause, without saying anything other than it's not working out or we're going in a different direction, and then terminate the person for that under those rules.
Excellent. Marissa asked, can you discuss manager supervisor personal liability or possibility of being sued in a lawsuit?
Yeah, I certainly can. Under the EEOC law, the federal EEOC and all the state laws I've ever practiced under, and supervisors and managers are not personally liable for in discrimination cases. And they could be liable for defamation. However, there's something called um, it's a protection where employer if you don't talk outside the company, if you tell your so line supervisor tells manager and HR, I think this person's impaired. They're drunk. And you that person has protection, qualified. I hate to use the word qualified immunity, but that's kind of what it's called. Qualified immunity to discuss what's going on in the workplace. I had a case where the employer got sued for defamation. The owner and the manager got sued for defamation when they went outside the company, told their computer rep that so-and-so stole from the company, and they got sued for defamation. So if you do not take it outside the company, and the only people that discuss this situation are those with a need to know, you will not be, you can maybe get sued, but there's no liability.
Wonderful. So this is a two-part question, Tom. Going back to the previously asked questions, Kim asked, is that the same as the right to fire state? And
Well,
then
I've never heard
Catherine
a
asked,
term, never heard a term right to fire, but the answer would, I mean, I think that's another way of saying the at-will rule means you have the right to fire anybody for any reason or no reason, as long as it's not for an illegal reason. So I would say right to fire at will. I like the word at will better, but you know, right to fire is pretty much the same thing. Yep. As long as it's not for an illegal reason.
right, perhaps at will is a euphemism for right to fire, but sounds like they're synonymous with each other.
I'm thinking so.
Yeah. Catherine also asked, is it best to term in at will state, term without cause?
Well, you know, if there is cause, let's put it down. I mean, if there's no cause, then you're just finding a way to, you want to get rid of somebody, fine. But if there's cause, remember unemployment laws, right? if a person gets fired just because, they're going to get unemployment. But if they're fired for violating a company rule, like, drug test, they come to work inebriated, they punch a fellow worker in the face. If you have cause, fire for cause, because that way you can defend your unemployment claim. But if you don't want to go that route and you don't mind paying unemployment, just get rid of them. We're going in a different direction. Your service is no longer needed.
Love it. Okay. The next question is submitted anonymously. Is email documentation to an email of corrective actions conversations enough, or do you recommend specific forms? So is
Uh,
email documentation enough, or are there specific forms? What's the best practice there?
well, I think an email any documentation is good documentation. An email documentation is excellent because you're using the company facilities, you're using company processes, and you're warning the employee through an email. However, it's always good to have a corrective action form, and if possible, to fill it out and have the employee sign it. Unless you have a way of tracking that the employee actually received the email, and maybe if the person responds to the email, of course, you're in good shape. But if the person doesn't respond to the email, how do we prove that they got the email? Right. But on the other hand, if you have a form, even as simplistic as you can make it, and the person signs it, then there's no question that you told them and they got it and you covered your bases.
Got it. Okay, next question. When we have someone who witnesses the suspected impairment, should we ask them to provide a written statement of what they observed?
Absolutely yes. Absolutely yes. Because there's nothing better than written documentation. Remember at the beginning of this session, I said, remember one word, that's documentation. There's nothing better than a written statement of what the person observed this other employee was doing. So absolutely, that'd be terrific.
Excellent. Next question. Do employers need to have an employee who had impairment signs sign a consent prior to having them tested?
I'm going to defer to ArcPoint, but I think that would be under state rules. State law in Arizona, you don't need the person's consent if there's reasonable suspicion or random drug testing that's done randomly for sure and not because somebody's of color. So random drug testing, you do that like once a month. You pick 10 people out of your company. You do it every month, no problem. For cause testing, when they get in an accident, you don't need consent. But again, I don't want to, if you're in like New Jersey or you're in California, or God forbid you should be an employer in California at this point, but that's okay. But or Montana, I mean, you'd really need to check and see. But I think in most cases that I've seen in New York, California, when I worked there in the 70s, and in Nebraska, and here in Arizona, you don't need written consent, especially if you have reasonable suspicion or you have a company random policy for drug testing.
So I tell clients during my reasonable suspicion trainings that I facilitate, and many of our owners do as well, is, if you're seeing, hearing, smelling indicators of potential impairment and a reasonable suspicion test is required, or at least it's an option, their consent is not a requirement to request the test, right? Now you try to influence positive outcomes, you try to influence compliance. You want them to proceed with your request and actually get tested. But at the end of the day, they can say no. And then, of course, at that point, you follow company policy. They speak to HR.
Which would which would be to say, see you later. Don't let the door hurt you on the way out.
Yes. Yes. Another anonymous employee, or excuse me, attendee says, what if an employee refuses to sign the corrective action documentation or
Okay,
form?
this is where you bring in a witness. Hopefully, it'd be a management witness, not a coworker witness. And you bring that person in and you say, I'm giving Sally and Jim this corrective action notice. They refuse to sign it. Would you please sign this for me to document the fact that I gave it to Jim and Sally, and then date that and thank you very much. You want to have a witness that will be able to substantiate that you actually gave the um, gave the documentation to the employee.
Next question. Sarah asks, in consideration of being within an at-will state, if the employee is termed without explanation, how strong of a case can they build on a claim for being wrongfully terminated, being part of a protected class?
Well, I mean, the only way they're going to be able to prevail in that case is if they can say that people that are not in a protected class were treated differently than they were. So if you just terminate them and say it's not working out, we're going in a different direction, they're going to have to come up with some reason why they were termed and somebody else in a non-protected class were did not get fired. It can be a lot harder for them to prevail in a case like that.
Okay. This next question comes from Miss Colleen and Wendell. Can I
Hello,
label
Colleen
every
and Wendy.
employee? Can I label every employee as safety sensitive?
No, you may not label every employee as safety sensitive, and you know that because I've already told you that. But yeah, so
All right.
your receptionist cannot be in a safety sensitive position unless they take a company car or their own car and go to the bank and drop off deposits. During that particular time, they would be in a safety sensitive position. But not every employee in every company is safety sensitive. You got to look at the heavy duty machinery, things of that nature. But thank you for asking that because everybody might not have known that.
Yeah, it is fair. And for context, everyone listening in, Colleen and Wendell are the reasons why Mr. Cope is with us today, and he was with us last month. They're out of Arizona, Arc Point Labs owner in Tucson, and they've heard Tom speak dozens, hundreds of times, perhaps. I don't know. Um, so yeah,
At least twice.
at least twice. And then Colleen did resubmit and said, it may be a silly question to the experts, but it is a question that they receive on a daily basis.
Yeah, and which is why I don't
Fair
want
enough.
to, which is why I don't want to poo-poo it. But the answer is
Right.
no. You
Right.
cannot have everybody be a safety sensitive position.
Looks like the last question we have here, Tom, and then we can start to wrap things up. Tracy asks, um, it is for pre-employment drug testing. Is pre-employment drug testing, should you get an employer release as along with the company doing the drug testing?
If I understand the question right, if you have do you need to have the employee consent for pre-employment drug testing? The answer is not necessarily, but most cases you don't do your pre-employment drug testing until after the offer is made. So once the offer is made, then you send them to pre-employment drug testing. The offer is made contingent on them passing the drug test. And you don't need consent for that because if they want the job, they're going to consent to the drug test. But as long as you do it for everybody in every single position, or maybe you have a carve out for only safety sensitive positions. But if you're going to do it just for safety sensitive, then everybody in a safety sensitive job gets tested pre-employment.
Okay, look in here, make sure there's no other questions. Well, no other questions coming through. One last question, and then we'll wrap things up officially. Desiree asks, if we have reasonable suspicion of an impaired employee, we test them on site, and the results come back presumptive positive. What procedures do you recommend post positive result?
Well, I can only speak in Arizona, and Colleen and Wendell can correct me if I'm wrong, but you have to have an MRO review if that happens, so they make sure that um, the employee is tested properly if you're doing it on site. I'm not going to tell you not to do it on site, but I do find that when that happens, I don't see as much consistency as I would see if you send them to Arc Point. Let's put it that way. And I'm not selling Arc Point more than, anybody else, but of course I am, but don't, don't tell other people that. But yeah, I definitely think that I see a lot less consistency with the in-house drug testing. I mean, I had an employer once who, told him to pee in a bottle and had a litmus paper and put the litmus paper in the sample jar, and if it came out of color, then the person was positive, which made zero sense. So make sure if you're going to do in-house drug testing, you do it properly.
Fantastic. Well, we have come to 5 minutes within the hour. Tom, I'm going to ask you one more question. Final
Go
thoughts before we wrap up. So think
ahead.
about what that final takeaway may be. So people hang on for just a moment. Tom, I want to say thank you so much again for presenting once again for our Points Thrive series. Presented last month, presented this month. Both were on point. In fact, as I was listening to you present today, I was struck and reminded of the purpose of our Points Thrive webinar series. Right, this Thrive series is designed to educate, enlighten, and inspire members of the ArcPoint network. Yes, absolutely. But most importantly, they're designed to help members improve some aspect of their business, right? The work they perform, and even some aspects of their personal life, depending on the topic. And we want to deliver our webinars in a way that are both professional and also conversational in a manner that nurtures trust, connection, and a sense of community. Now, I say all that because you were able to deliver both webinars in a manner that was both professional, conversational, very relatable. In fact, I was looking back in the chat and I saw that Catherine D and Jenny W were communicating with one another. So talking about trying to create a network, a virtual network community of like-minded professionals trying to educate themselves and grow in their profession and their practice. I got to see it real time today, and that was really cool to see. So,
Oh,
Tom,
that's
thank you
true.
so
That's
very
true.
much. Yeah, please let Tom know what you thought about today's webinar by completing the post-webinar survey. The survey link is now in the chat. It will also pop up in a separate window once this webinar concludes, provided you don't have a pop-up blocker installed. Also, let ArcPoint know how we can make your job easier, your business more compliant, your workers happier, healthier, safer, more productive. It's what we do at ArcPoint, and it's what we love to do. So keep the feedback rolling in. Next, if you are a credentialed HR professional, please look in the chat for your activity IDs. These will also be listed on your certificate of attendance, which will be emailed to all participants by end of day next Tuesday, provided you attended the entire webinar. Next, as we talked about earlier, registration for our June Thrive webinar with attorney Jenna Shives is now open. You can register for that webinar right now for free by clicking on the link in the chat. And as always, as Tom mentioned several times, I'm going to reiterate this point now. If you have any follow-up questions about today's topic, you're encouraged to reach out directly to your local ArcPoint Labs provider, especially if you have questions about drug testing, policy development, staff training, supervisory training, reasonable suspicion or signs and symptoms training, and employee assistance solutions. Check out www.arcpointlabs.com/employer-solutions to learn more about all those solutions and many others, or simply click on the link to that webpage, which is now in the chat. All right, as promised, Tom, we've reached the top of the hour, covered a lot of ground this past 58 minutes. Any final words of wisdom?
I do have final words of wisdom. The final words of wisdom are three things. One, documentation, documentation, documentation. Two, if you have any follow-up questions, my email address is on the slide deck. You may have already had it from the previous session. Please feel free to email me your questions. I will answer them as best I can for free, no charge, and just glad to do it because you're part of this seminar. All you have to do is put ArcPoint Seminar in the subject line and let me know what your question is. I will answer it as quickly as I can. And finally, let me end this. Remember to act. Action changes things. ACT, action changes things. Be proactive. Do the right thing for the right reason. I wish you the best going on for the summer. Those of us in Arizona, we're going to try to stay cool. The rest of you in the United States, I wish you the best. And thank you again, Ryan, Kisty, and the local Colleen and Wendell connection. Thank you very much. I appreciate your time and the fact that you attended this program with me as the leader. Thank you so much.
Absolute pleasure, Tom. We're going to try to get you that personalized ArcPoint shirt, all right?
Yeah,
You
sounds
just
good to
let
me.
us know the color.
Blue.
Blue. All right. Well, it's perfect. Well, on behalf of the entire ArcPoint team, a very special thank you once again to our encore presenter today, attorney Thom Cope, and to everyone attending, our valued partners and loyal members of the ArcPoint network. It's an honor to serve you and to help you create compliant, safe, and healthy workplaces that thrive. We'll see you next month.